These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
We're going to start with a secured debt situation. And like I said, we're going to superimpose a template for building any and all processes and achieving remedy. And we're going to fit this into that template and then go over specifically the examples. So a good thing or a good practice for figuring out what it is you want to do in order to achieve your remedy is to first, because what we're doing in creating our remedy is we are simulating how the remedy would be achieved in the public. Now, I specifically chose the word simulate because a simulation is taking on in form or appearance, as well as imitating. So even though we're going to be doing it from the private, how things play out in the public will look in form as they would in any public remedy or contract. So in the matter of a, let's say, mortgage, first you want to, before you build your process, look at what would this process look like, what would the form be in the public if I were to seek my remedy publicly. So first, let's take a mortgage. How would the remedy or the resolution of that account look in the public? Well, first let's identify and make distinctions of all the elements. Okay, all the pieces that we're going to be dealing with.
You have to get your payoff.
Okay, well, hold on. Before we even move into, what are the things we're dealing with? Okay, there's a deed of trust. What else?
Promissory note.
Okay, there's a promissory note. What else? A what? Okay, that's all part of the deed of trust. Those are elements inside of these. We could actually break down each of these and make distinctions. Okay, after the deed of trust, what came? Deed of trust is a lien. Okay, how about this? What came before the deed of trust? Well, before that. Okay, there was an application. And then what came between the application, promissory note, and deed of trust? What about the grant deed? Right? Some form of grant or warranty deed. Okay, so then we had the deed of trust. What came after the deed of trust? What are you dealing with the bank? Title came with the grant deed. You already have title. Payments on what? No, you're not making payments on a note. What does it say on this document you receive every month? What's it say at the top? Statement of account. So there was an account created. Alrighty, any other elements that we need to be concerned with?
Taxes, maybe?
That is its own account. You have a separate account for property taxes. Okay? All right, so we've got these elements that are in place. Now, if we were seeking publicly to bring this to a close, we're looking to close the account and remove the lien, right? So perfect the title. What would it look like in form in public? Okay, well, how would you bring an account to zero in the public? Pay it off. Okay, so first it would be paid off. Then what happens? Release a lien, satisfaction a lien. What is, in California, by form, we have what's called reconveyance of deed. Okay, so you're really looking for a release of the deed of trust or mortgage agreement, depending on what kind of a state you're in, right? It'll be a deed of trust or a mortgage agreement, which is a lien. So we're looking for a release of the lien, which could take on the form of reconveyance of title. It could be a document called release of lien. Okay. Anything else on the public side in form? Anyone know what happens between mortgage company, title company? Assignment of what? Assignment of an interest upon the release of the lien. Who gets this? Okay. So yeah, that part of the form will be that whatever the release of lien is gets filed, right? So a couple of these elements get filed in the public. Deed of trust, grant deed, release of lien. Right? Those are some of the elements that get filed into the public. Are we done? We have the home free and clear at this point? What else is there? They said public side. There ain't no such thing as a loyal title in the public. Statement of account showing zero, right? But that would probably come right after payoff. So statement of account. Shows zero balance. Anything else? Once this reconveyance of the deed has happened, is the property free and clear? Besides property taxes. Yes? No? Any clue? What else is there? You need to get what deed in your own hands? Do you get the note back? Nope, not necessarily. Maybe some states. I imagine, like most paper commodities and securities that are currently moving through commerce, that they have been digitized and the originals probably shredded. So you may never see that note again.
Can't you win on that basis alone?
We're not talking about arguing the facts here. Okay? We're looking at how a creditor brings remedy. Creditors don't argue facts. Okay? We're not here to argue facts. We're not here to challenge anything. We're here to what? Simulate a settlement. So that in form it looks just like any other settlement. So if I wrote a check off of a public account, which fully satisfied the amount owed on the account, I would get some kind of a reconveyance. And at that point, is my property free and clear? In the public, right? Okay, so our process is going to simulate this. Anything outside of this box in form in the public, you're going to be creating probably more problems for yourself. So, nothing about UCC 1s, right? It's part of the typical public process filing a UCC 1? No. Does it have anything? Is anything else recorded in the county records on the property besides the reconveyance? No. Now, there's a couple other elements we can add to this if you are already in default. Okay? If you are in default, what else would be a part of this public form? Well, no. I didn't say you lost possession. I just said there was a default. The notice of default was filed. Why? Is there litigation? Judicial states are saying there's a lis pendens because it's in default? For whose benefit? Who's the secured party on that lien? Okay, so in a mortgage state, a lis pendens lien is filed with the court. Okay?
Lis pendens meaning pending suit.
Pending litigation. That the title is now in question and nothing is to happen on this title until the litigation has been resolved. Okay? Now, again, we want to simulate what happens in the public. So let's say notice of default went out, but now I wrote a check for the full amount owed. What would be added to this process? Satisfaction of default. What goes into the public record if the default has been satisfied? If there was a lis pendens, would it be released? So there'd be now a release of lien. What cancels the default? What in the public record shows that the default has been cured? Notice of rescission. The default has been rescinded. Okay, so before the release of lien, there would be a notice of rescission. typically in a public transaction? It's filed by the trustee. Who orders the trustee to file things in a deed of trust? No. Beneficiary. Beneficiary tells the trustee, notice of rescission. Beneficiary tells the trustee to release the lien or to reconvey the deed. Okay, so that's what it in form looks like. So our process from a public point of view will look exactly like this. Nothing out of the ordinary. So get that in your head, that before you even start your process, what would this look like? For instance, let's say there was a judgment. Let's say now I'm stepping outside of this scenario, and I'm saying there's a civil suit where a judgment was rendered, and let's say it was a complaint for money. And so now you've got a judgment against you for an amount of money. What would that typically look like? Okay? Payment was made, right? So we got another payoff. If they had filed that in the county as a lien, under the abstract, like they filed an abstracted judgment into the county records, there would need to be some kind of a release of the lien. Maybe something like a release of judgment will go into the court case itself. Okay? So that model, what's that? Satisfaction of judgment, something along those lines. And again, who would execute a satisfaction of judgment? Does the defendant execute it? The judge? But who initiates it? Or the plaintiff? Right. Okay? So again, we're going to simulate the public process with our private process in the background. None of our private process ever makes it into the public. It stays private. Okay? So the public will always look the same. Even if we're using private processes to achieve our remedy, in the public, it will look as if any other payoff had happened. So paying with a check will look just like paying with your private asset account in the public. Now, we all know that the process is much different. Writing a check typically is a lot easier than executing an administrative process. So, that being said, let's look at the private process that will lead us to simulate this public model. Okay. First thing we want to do, I'm trying to fit all of this up here. Okay. Move this chair. All right. Everyone can see these, right? You can see this? Okay. So how a creditor brings remedy. What's step one? Settle the account. Just like here, right? Before any of the public record is going to show the satisfaction of this account or the satisfaction of this situation, first the account needs to be settled, right? So we're going to settle the account. Now, we're not going to write a check. Well, you could write a check. But if you're doing a private administrative process as a creditor using asset, you're not going to be writing a check off a public account. But you need to have the knowledge, the fortitude, and the competency to execute a private process and use your asset account to set it off. So here you'll see a list of the documents for step one. Can everybody read that? I was trying to figure out a way to make the words bigger, but I couldn't figure it out. So we've got if you can't see, document number 1 there is a notice to set off. All right, so we have a notice to set off. Actually, so I see I actually separated the documents. There would also, there would also be a negotiable instrument that goes into step 1 here. Where are my instruments? This process, instruments, okay. So one of these, and for these purposes, I'm going to choose money order. Okay, so this bottom half, just so you know, this money order that's going to be in your samples, you would detach it right here at this line, and all you would submit is this bottom portion. And you would not only sign it down here under authorized representative, but you would endorse it on the back, just like an endorsement of a check, okay? This memo account here would be your Social Security number, okay? Alrighty, so
Have you used this for mortgages worked?
I've never used this on mortgages. I use the bonded promissory note, but I don't have that. I don't have the sample bonded promissory note in that folder yet. So I typically.
Have had luck with paying off mortgage or somebody has.
Hold on. We'll get there. I'm going to show you how you are not dependent on anybody doing anything in this entire process. Okay? So you're not waiting for someone to do something for you. If you've tendered the instrument, boom, sufficient. Payment's been made. And you're going to get everyone's agreement that it satisfied the debt. That's all you need. Okay? Now, you could choose your instrument. You could use the bottom half of your payment coupon on your actual mortgage statement if you chose, and do an accepted for value on it.
I did all that. I haven't.
And you're waiting for somebody to do something, aren't
done
you?
anything back.
You're not waiting for someone to do anything back. That's not how a creditor operates. Okay? All righty.
I thought I see 0 on my account.
So now you're waiting for someone else to issue the statement of account.
Okay.
Let me get through step 1. Okay. So on step 1, we had the documents, and I added an instrument there. Okay. Like I said, it could be a bonded promissory note. It could be the mortgage statement itself with your acceptance statement on the front and back, and make the payment coupon into a money order. Okay? You could make your own money order like the one we're using right here, or you could use a bonded promissory note. You can use a certified payment bond, whatever you choose.
What is a bonded promissory note?
Bonded promissory note necessitates that you already have something on deposit with Treasury, the way that we've structured ours, because it's basically putting up that account or those bonds as the bonds to set off the debt, and the note is the instrument to make that happen. Okay? So if you don't have those in place, don't worry about it. Use something else. Okay? Those of you who have indemnity bonds and set off bonds on deposit with Treasury, then you could use the bonded promissory note. What's that? Well, no, this is my own. These are my own folders. Yeah, no, it's not going to be in here. But I do need to change that to view. Okay. All right, so back to step 1. Okay, so we have, right here in step 1, we have a notice to set off. Now, this particular, I think yesterday we mentioned how we're going to tender our set-offs through the IRS, correct? All right, so that's how this particular process is structured. So we're going to issue a notice to set off. We're going to issue our instrument. Now, if you have a statement, like let's say you got a payoff statement, that would also be included in here. All that's in this list are original documents that we're issuing. However, there should be some evidence of the debt also sent in this process. And that evidence of the debt should have a banker's acceptance front and back. If it's a 4-page evidence of debt, let's say you get a 4-page statement, each page, back and front of each page, would have your acceptance statement on it. Accepted for value, return for value, or accepted for value, exempt from levy, deposit to United States Treasury and charge the same to, blah, blah, blah. Whatever acceptance, banker's acceptance statement you use would be front and back of each side of each page of the statement, of the evidence of debt.
Back to?
Front and back. Okay? So we have the notice to set off. We have, of course, have our instrument, which is the money order. We have our evidence of debt. We have a 1040-V, and I also have a document here which shows what special endorsement goes on the back of that 1040-V. And a process that me and my friend Doug have created, we've incorporated this into our process, but what I would suggest is that unless you have a Treasury Direct account like we do, that you eliminate these points from your process. See, what we do is in our notice to set off, we basically instruct the IRS that if there are any overages or any amount of money to be returned, that it's to go directly to the Treasury Direct account. Okay. Yo, did you get a check back on A for V?
On the mortgage thing,
Yeah. So, well, this is on our, for what we're doing, it's for, we've actually had people who've done A for Vs through IRS and gotten checks back. And so we're instructing the IRS that we don't want a check because we're creditors, we don't create debt. And what would happen if I took that check, endorsed it, and deposited it into a bank account? I've converted my private asset into public debt.
Yeah, I did that. They reversed it.
They did reverse it. Okay, see, you don't want it to go, we're not even authorized to create public debt out of our private asset. And we don't want to as creditors. That's what the banks do. They are authorized by Congress to convert your private asset into public debt. That's what happens on your promissory note. Your private assets are converted into public debt. So what we're doing is we're instructing them as a part of our notice of set off to don't send us a check. Send that to our Treasury Direct account. Why would I have it sent to a Treasury Direct account? And what's significant about Treasury? What do you do with the Treasury Direct account? You buy government securities. What does that make you if you buy government securities? A creditor. You're actually turning your straw man into a creditor of the United States. Because what you would do after that money ends up in that account is buy bonds and notes of the United States. When you buy bonds and notes of the United States, you're the creditor. So that's why that IRS Form 8888 is there. That's where we put our account information for our Treasury Direct account. So like I said, you don't need to use this part of the process. Because of where we're at in our processes, we have this in the process. But most people don't have a Treasury Direct account, and I wouldn't suggest you do this unless you have one. Okay, and then we have our certificate of service. Now we're going to look at these actual documents for step one. Oh, shit. Hey, Garrett, can you unplug my antenna, the little receiver for this thing, and plug it back in? Stop working. It's on the back. It's on the back. Just unplug it and plug it back in. Did you unplug it? Do it again. No, I got it. Got it. Okay, so notice to set off. So, how do I distinguish my private contracts? Well, an easy way is to put this little notice at the top of all my private contracts. This is a private communication between the parties. Notice to agent is notice to principal. Notice to principal is notice to agent. Notice to set off accounts. And I'm also very selective in prepositions that I use. This is notice to set off accounts. And in fact, that's not a very quantum way of saying it, so that preposition is actually an adverb, but it's showing that this is a notice for performance. I could call it a notice for performance of set off of account. So I'm basically noticing who? Who am I giving notice to? IRS Tech Support. Now, because lately we've been having success at a faster rate going through Ogden, typically we direct this through the mail stop 4440 at Ogden. Okay, this particular one has the address for Technical Support Division at Washington. You can use either one. You could contact IRS and say, where do I send set-offs to? Where's the best location to do set-offs? Because we used to use a location in San Francisco, but they don't do them there anymore. So a year from now, 6 months from now, 2 years from now, this may be irrelevant information. And a way for you to find out where the relevant place to send it to would be communicate. Open up a line of communication and figure it out. If I've got a tender for set-off, where does it go? Okay? I have a little line here for service, and this is by registered mail with a return receipt. And there you would have the registered mail number. Here, it's giving a brief description. Whoa, whoa, whoa! Slow down. It's giving a brief description of what's included. Okay? This particular document is designed around a franchise tax board debt. So rather than there being, number one, a original notice of state income tax due, this would be an original mortgage statement of account, or whatever the title of your monthly statement is. Issued by name of the bank who issued it, and dated whatever the date of the statement of account is. Duly endorsed as follows. What's duly mean? In accordance with, proper. And then it has there the acceptance statement that is endorsed on the front and back of the mortgage statement. Accepted for value, returned for value, exempt from levy, prepaid common stock, discharge all presentments and related fees, adjust the balance to zero, private prepaid treasury account number, blah, blah, blah. Charge the same to whoever at blah, blah, blah. Okay? Signature and date. And then number 2, original IRS 1040V payment voucher, duly endorsed as follows. So this is also the endorsement that appears on the back of the 1040V. Number 3, original IRS Form 8888, direct deposit of refund to more than one account. And that's where we put our account information, God darn it, for our Treasury Direct. Okay, so these instruments are being tendered by so-and-so, hereinafter principal, for the set-off of, let's say, ABC Bank account number, whatever, and are to be used to effect debit and credit accounting transactions for the settlement and closure of said account. If any of the enclosed instruments contain any defects or are incorrect, incomplete, or inaccurate, please return the same to the principal via the notary public at the address shown above within 10 days from the date of receipt. No, it's not. Somebody else typed up this document. Actually, my friend, whose name I erased from the money order, he typed this one up. It's not that it's improper to have it separated, because they both would have the same meaning. And you could find definitions for as a compound noun and as two separate. Okay? It's just as far as language goes, when you compound it together, it's clear that it is a noun. and that there's not an adverb-verb relationship between the two words, to set off. When we combine them together, it's a set-off, right? Alrighty, so so-and-so, account number 1, 2, 3, 4, 5, 6, 7, 8, 9, has an open Treasury Direct account, blah, 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 established with the Bureau of Public Debt for the purpose of purchasing and setting off public debt with private equitable assets, as outlined in the Chicago Federal Reserve Bank's publication entitled whatever. The included IRS Form 88 indicates the account number and routing information associated with said Treasury Direct account to ensure that any credits, refunds, or overpayments are directed to this account and not returned to the principal in the form of a check, promissory note, or other liability instrument. The principal hereby grants and conveys to the IRS Technical Support Division or any of its agents the authority to direct any refunds or overpayments as credits ledgered to account whatever. Please exercise ordinary care as the party entitled to enforce these instruments to ensure that all debit or credit transactions ledgered to both the bank account and, in this case, the Treasury Direct account and the straw man name and account number are done so in the best interest of the United States Treasury. Thank you for your consideration. I look forward to a relationship that is mutually beneficial to all parties involved. Until then, it is my pleasure to always be. Okay? So that is our notice to set off accounts. Now, lately, we've been doing this step 1. Now, like I was just making the comment a minute ago, that we're not depending on anyone to execute anything in order for us to complete this transaction. However, as far as proper form goes in getting set off via private asset through the IRS, it is more likely to be properly processed by the IRS if you do not include this form. And we've actually been perfecting a process where we do not use this form in step 1, where all we send in is the money order or instrument, which could be the endorsed payment coupon, the evidence of the debt with the acceptance on both sides, and the 1040-V. That's it. We still present it through a notary, however, but we do not include the certificate of service for this process in the packet.
So in a very simplified statement, you're saying we're just going to henceforth ignore this notice to set off accounts and it won't be part of any record. However, those 3 items to the IRS will be there, plus a 4th item called the certificate of service we keep in our own records for future use.
Exactly. And I will show you tomorrow when we do the traffic ticket example, I will show you this step 1 just like how we explained it, where there is just those essential elements there. Okay?
So when we get this record, we're just going to pretend like this notice to set off accounts doesn't exist.
You could do it either way.
Right.
Okay? I'm just saying that again, you're building your own process. We're giving you a sample, and what was the essential part here? Settle the account.
So the important part is that we need to know that when we submit that payment bond, promissory note, coupon, whatever it might be, with our A for B and our 1040, that there's acceptance. And we now have a binding contract, and whether we add a notice to set off account or not is not the issue. No. We need to know that we paid that thing, they accepted it, and that's the real issue, is it not?
Absolutely. Because who's the only party that can rebut whether it was, can the bank rebut whether the IRS accepted payment on their behalf? No. That's why there's only one step with the IRS. I don't do a notice of fault. I don't do a notice of default. I don't even need a certificate of non-response. Because the IRS is the only one who can rebut whether or not they received it. And I have testimony from the notary that it was served on the IRS.
I.e. through the certificate of service that we maintain for our records to be sent later.
And keep in mind that the notary's record is not just the certificate of service, but a copy of everything that was mailed. So, if what I mailed was the evidence of the obligation, the mortgage statement with the endorsement, the promissory note or money order, or the payment coupon made into a money order, and the 1040-V, the notary would have copy of all three of those documents, along with the certificate of service. That is a record, the notary's record of what was sent. It's important to make that distinction, that this is the notary's record. And it is important for you to know that it is complete with all the elements, not just the certificate of service. Why is it important to know that this is the notary's record?
Because the notary will be testifying later to that effect.
Not necessarily. The notary won't necessarily be testifying later, but what makes it significant that this is the notary's record, not my record? It's a witness, a third-party witness. Not only that, it is the notary's job to keep such records. Anyone remember yesterday Jack talking about exceptions to the hearsay rule? One of the exceptions to the hearsay rule is a record kept by a third party whose job it is to keep such records. And the notary's job is to witness. And it is their job to keep records of that which they witness. Why do we use notaries? Because they're official witnesses who have capacity to act on the private and public side. What better character is there for our private process than a notary? Notary is the best thing.
They're actually deputy clerks of the Superior Court as well as representatives of the Secretary of State's office. Agents.
Okay, so you've all, I'm sure, seen a 1040-V before?
No.
Gosh darn it, dude. My freaking... No, the batteries are fine. I actually just changed them out. It's quitting on me. It is cold in here. Okay, I got it.
A little bit in here or no?
Okay, this is a 1040-V payment voucher. When you send this into the IRS, you leave it attached to the top part, even though there's a little line for detaching it right here. You would place the Social Security number of the taxpayer in. You would place the name, all caps, first name, middle initial, and last name of the taxpayer. You would put the address, residence of the taxpayer. And up here in box number 3, you would leave it blank. Why do we leave the 1040-V amount blank? Why are we letting them fill it in? So it's accurate. There may be fees that Treasury demands for performing this service. There may be penalties or interest in addition to what is on our statement. And our endorsement has told them, set off all penalties, interest, and related fees and adjust the balance to zero. This is so that they can make any and all adjustments. That's why the 1040-V goes in it.
For clarification, I was told the ES for during the year and then the V at the end of the year.
No, that has nothing to do with this process. You're talking about something that goes along with OIDs and 1040s.
Okay, so use the V.
This is for putting in a payment instrument for set off through IRS. Okay. So the reverse of the 1040-V would look like this. So remember, we just took that piece of paper and flipped it around. So this endorsement is where, in relation, the same place that you would endorse a check. Is it not? And this is the endorsement. Accepted for value, returned for value, exempt from levy, prepaid common stock, discharge all presentments and related fees. This is the adjustment. Adjust the balance to 0. Private prepaid treasury exemption number. Charge the same to taxpayer account.
And for clarification, what color signature would you put on the line?
Blue. And why?
To indicate an original.
Because it looks good, because it's pretty. That's Tim Turner's famous. Why do we put it in blue? Because it's pretty.
Brandon, on that endorsement, do you have to have a stamp like that printed on there, or can you handwrite it?
You could write it. I've
can.
handwritten this endorsement before. It's not better or worse. I've had it work both ways. It just, my hand starts to cramp when I write a lot, because you got to write it in such a small little space, because you want this endorsement to fit underneath. Even though you're not detaching the top, you want this endorsement to fit as if it were detached. Okay?
But if you wrote it in your own hand, you'd still have to make it all caps and print it, or could you use...
You want it to be legible.
Right.
You want it to be clear what it is you're instructing them to do. So yeah, I could write "pay to the order of" on an endorsement, and I could write it in hieroglyphics, but is that going to do me any good? Or cuneiform, or Chinese. Maybe if I was depositing in a Chinese bank, it would work. But at Bank of America, they go, "What the hell does that say?" So that special endorsement kind of loses its effect if it's illegible.
Last thing, do you send all this certified, or
Yeah, you could send this certified.
Or how about registered? It doesn't matter.
The funny thing is, I've run into more problems when we send these in registered. I don't know, and I'm sure I can rationalize that as well as looking at it from the point of view of, well, this is being done on behalf of the taxpayer, public side, right? So that's why it could be seen to be sent in certified. Now, if I were using the bonded promissory note as the instrument for set-off, I would most likely send it registered. Anything besides the money order or the payment coupon made into a money order, I would probably send it registered. So for instance, if I'm sending a certified payment bond, if I'm sending a bonded promissory note, I would send it registered. Absolutely, I would. That's me personally. But whenever I'm doing that type of an instrument that's attached to multi-million-dollar bonds that I have on deposit with Treasury, I want there to be some protection with this. An extra level, above and beyond what certified offers, and that's what registered is. Okay. So now, we'll take a quick look at the certificate of service. Certificate of service now. That's the address that we are sending them to now, which is different than the page one. Remember, do not just go through this document and replace names, because you could see from step one that we're all over the map. I've given you the essential elements of it, but if you don't read this completely and everything match up, you're going to have one screwy process. You're going to be addressing it to one party, testifying that you mailed it to another party. Okay, so just be careful on how when you go through these documents, that you make this your own. Because I literally just threw things together. Okay, so basically this is the notary testifying that what they did was mail all of these documents listed to the party noted at the top. And you notice it has the notice of set-off accounts issued by the name of the person issuing it, the date of that document, the number of pages in parentheses. That would be, number 2 would be your mortgage statement, and issued by the bank, and the date of the mortgage statement. And then I even put on there with banker's acceptance endorsement on front page and reverse page of leaf. You know what that means? Front page and reverse page of leaf. What is a leaf and what is a page?
A leaf is a sheet of paper, and a page is one side of a leaf.
This is a leaf. This is a page, and this is a page. So this is 2 pages. 1 leaf. So I made the distinction. And that's why in parentheses it says 2 pages. In most people's mind, this would be 1 page. But that's why I made the distinction of front page and reverse page of leaf. And then in the parentheses, 2 pages. So that when we get down here and we have the total number of pages, it counts that mortgage statement as 2 pages. How many have ever gotten something from a court that is and then
Yes.
Nobody ever seen that? You've seen that,
Yes,
huh, Gordon?
many times.
Yeah. Because that's 2 pages.
You'll also get some from the court where it says intentionally left blank.
Yeah, on the back side. I've even done that. I've done processes where I only print on the front side of the sheet, and every back side of the sheet had in brackets intentionally left blank. So even though there may only be 10 pages with printing, it is a 20-page document because there are 10 leaves and 10 pages intentionally left blank. Or I could see it as 1 continuous page with this whole part of the page left blank. So that's why that distinction was made in number 2, so that when the total, they're not just counting pieces of paper. Number 3 is the 1040V, payment voucher with banker's acceptance endorsement on reverse page of leaf, right? Dated. Now, where does the date on a 1040V appear? Does it appear on the front? It appears on the back where your endorsement went, because there is no place for a date on the front of a 1040V. And issued by or issued for account, and you have the taxpayer account information there. It is listed as 2 pages. Why is it significant for me to make the distinction that the 1040V is 2 pages?
It's actually writing on both pages.
Right. If I say it's 1 page, the endorsement isn't there. Number 4, remember that's the Form 8888 for Treasury Direct account. And number 5, now this is an important distinction because remember I said we're no longer sending the notice to set off accounts and we're no longer sending this certificate of service. Number 5 is a reference copy of this notary certificate of service, 1 page, signed original on file. Now, if I am not sending this with my process, is number 5 going to be here? No. Number 5 would be removed. It's the reason why I'm making these distinctions is because I'm trying to instill in you the capacity of critical thinking. So that, because I've literally had people go, well, Brendan, this doesn't make sense that you have this here. That I go, change it. Like, actually, that was one of the things Garrett did once. Garrett was taking one of my templates for a process, and he was doing his own process. He's all, Brendan, it doesn't make sense for this to be here and this, that, and the other. And I go, and? He comes back a couple hours, because Garrett, I push him. Like, I won't even give him an answer. I'll just straight up say, okay, handle it. And he'd be like, damn. And he comes back to me a couple hours later. He's all, it's because it doesn't apply to my process. And I go, exactly. I go, when I wrote this document, it applied in my process. For yours, it may not apply. So you need to know who you are, own this process, and be like, oh, well, I don't need that, and I don't need that. But know, and don't just randomly, well, I want to make it different, so I'm going to remove this and this. Make sure that it's your document and your contract is relevant for your process. So if I'm not including this document, it stands to reason that number 5 would not be on the list. But they are still testifying that everything else was sent via registered mail at this registered mail number with the return receipt to the address above. Okay? So there we have the certificate of service. And you notice there is a, what's that? What's that?
The case you're talking about is not now 8 pages, it's 7 pages.
Yeah, exactly. Yeah. Again, of course, critical thinking here. if the number of pages changes, you better change that. I've actually even made that mistake before, where I'm like rushing to get my process out, and because literally I'll change my process 5 seconds before I'm sealing the envelope, and then I forgot to change that part. I'm like, ugh. Had 8 pages and I only included 7. Okay, so I would suggest, especially if you're just beginning, never rush your process. You can always nunk-pro-tunk it. But don't be racing to get your process out. That's when you really start to make mistakes. Ask my brother. When we first started doing this, we were trying to handle 10 or 15 debts at once, and everything was rushed. And we made ridiculous mistakes all over the place. Now, I marinate and I sit on my process. And I read it over and over again. And I still find mistakes. As seasoned as I am at doing this, sometimes I make stupid mistakes. Okay? So, don't ever rush your process. One of the best pieces of advice I can give. Yep.
On the V and on any of the stuff you sign, I think we're signing it as a creditor, so it's not a AR, right?
No.
No AR.
I don't think you'll see AR on anything that I'm doing here.
Right. And then without recourse?
Nope.
Nothing.
Nope. Be careful what you use without recourse for.
Also remember, if you abbreviate, that's not a good thing. So don't be using AR on anything. If you want to spell out authorized signature, that's okay, or whatever you're going to do, or authorized representative, but don't put AR there because it's not recognizable in law.
Okay, so we called that step 1, but here we are, step 1 is complete, and we haven't even addressed the bank yet. So step 2 is actually our step 1 with the bank. Okay? Now, I'm going to call it step 2 because you guys know that step 1, we were dealing directly with the IRS. Now, we were addressing the IRS in regards to an account with the bank, but step 1 had nothing to do with the bank itself as far as a party to the transaction. Now, the bank is a party to a transaction with the IRS, but we are arm's length from that transaction. Okay? So, step 2, 2 simple little documents. Well, you'll notice I usually put, usually my documents or processes, I put it all into one document. Okay, so this isn't just one document, this 2.2 notice of tender. It has my certificate of service in there. It has a request regarding a statement of account in there. There's different elements to it, but I put it all in one document.
Also has a copy of what you sent to the IRS plus your certificate of service.
Hold on. Well, not in the Word document. Now, we're making a distinction here. These are the documents of the template. The process itself will incorporate documents that we will discuss right now. Now, first, before I move to step 2, I have in here a certificate of non-response. What is that certificate of non-response for?
It's for your records.
Who is it on?
Be on the IRS.
Notice how it's 2.1. It comes before I've even corresponded with the bank. I've put these numbers in these orders for that reason. This is 2.1. 2.2 is the beginning of my action or contract with the bank. So before I go to the bank, what am I certifying? That the IRS didn't send me anything back.
IRS actually accepted.
That the IRS accepted the tender for set-off. Now, again, in the processes where I have not directed them to send a response through the notary, can I certify their non-response? No. Unless my official address with the IRS is my notary's address. You do understand that? Okay, so the notary cannot certify a non-response unless I sent that notice to set off accounts, which instructs them to send it through the notary. Understand? Okay.
You give them 30 days, the IRS?
No, 10 days. Just 10 days. Alrighty, so here we go. And actually, I will show you this just to... Oh, I forgot I already had it open, didn't I? Yeah, okay. So I just shrunk it. Okay. Now, it's important to make the distinction that all of these certificates are not the same. That they must be relevant for your process. So you'll notice on this certificate, there's no mention of a notice being sent out. Because I am not giving them notice of a fault or of a default or of anything else. This is merely the notary certifying that on this date, this was presented to these respondents, signed by this person, requesting acceptance, notice of defect, or notice of dishonor. Because a notice of dishonor would be the proper response from the IRS if they could not honor what it was I sent them. I've only ever received one notice of dishonor. It was from the Secretary of State on a credit card payment. The Secretary of State does it right. Better believe it. Even with public instruments, they do it right by the UCC. Because they're always working in international commerce. Okay. Now we will move on to document 2.2, notice of tender for set-off. So remember I told you prepositions are important. This is a notice of the tender for set-off. The last one was notice to set-off accounts. So what I'm doing is I'm noticing the bank now that a tender was submitted for set-off.
You said notice of the tender, yet the is not in the cap. Is that what did you intend to put the in there?
No, I said notice of tender for set-off. If you were to properly quantify that, it would be for the notice of the tender for the set-off. Okay? Or for the notice of the tender with the set-off.
Brandon.
Going back to the certificate of service, I noticed there were 2 lines on each side of the page. What is the purpose of that, or is there any purpose for that?
There's no purpose for that.
Okay, just makes it look nice. Okay, because when you put things in a box,
it's not in a box.
It's not there. It's not a box. I didn't know if there was a significance.
You will see boxes later, though. I do use boxes.
All right, thank you.
Okay, so we have labeled the notice with a date, with a registered mail number, same private statement at the top, because this is a private contract that we're initiating with the CFO. We label the creditor as the principal in this document. We label the CFO as the respondent. You see those labels? Right there? Principal, respondent.
And actually in full, it's principal debtor.
What's that?
If you wanted, you could say in full principal debtor, but I mean, you're saying principal.
Yeah, I'm saying principal, and really, it has no other significance than I could say lender. I could say Cookie Monster. It just means in this document, this party will be referred to as principal. It has no other significance other than that. So I could just say Cookie Monster, and the name, and then whenever I say Cookie Monster down here in the document, it means that up there. That's a definition. You see that? Yeah. Principal is being defined. Respondent is being defined.
What he's also telling you in law, that's important because like you take the United States codes annotated, they'll define United States 31 different ways in that document.
Exactly. So this is a definition. I have defined principal and I have defined respondents. This is regarding bank account number and one of the parties to that account, the debtor, right? Dear Mr. or Mrs. So-and-so, whereas on April 6, 2010, instruments of tender for set-off, hereinafter tender, all capital letters. What is that? No, I have defined tender as the instruments of tender for set-off issued on this date. Okay, so whereas on April 6, 2010, instruments of tender for set-off, hereinafter tender, for the set-off of mortgage account number, hereinafter account. I've just defined two terms. Account being the mortgage account. Tender being the tender for set-off that was sent to IRS. Were presented for set-off to, down here it has Tech Support Division, Washington, D.C. If you had sent it to Ogden, it would be Internal Revenue Service at Ogden. Whereas on April 20th, 2010, the tender is deemed accepted for the set-off of the account. Notice, now I'm using two of the words I defined. Whereas on April 20th, 2010, the tender, all caps, is deemed accepted for the set-off of the account, all caps, pursuant to and evidenced by the records enclosed herewith.
Do you notice a question, Brandon? I notice that you have April 6th date when the tender, and whereas April 20th date is deemed accepted. Maybe you could explain that to me.
In this particular process, the certificate of non-response was executed on April 20th. Now, if we had done a process where there was no notice to set off accounts and therefore no certificate of non-response, this could be 11 days after that. So it would be April 17th. Why?
3 days.
Why 3 days? Why can I deem it as accepted after 3 days? Anyone read reasonable time and seasonableness from the UCC? You better have. All my MIC students know what reasonable time and seasonableness are. In commerce, we have reasonable time and seasonableness on transactions. So I can deem it that because in commerce you have 3 days to dishonor the instrument, and allowing 4 days or 3 days for the mail to get there and 3 days for the mail to return and a Sunday, they've had sufficient time to dishonor the instrument or to return it for defect.
Seasonably meaning simply timely.
Mm-hmm.
UCC uses that word in that context.
Yes.
So
if you're
when
interested in finding it, you'll find it has its own little subsection. It's less than a paragraph in the UCC under Article 1. Reasonable time and seasonableness. Okay. Therefore, therefore, so-and-so. Now, even though I defined principle at the top, I am now restating that definition in the body of the document because those first definitions appear outside of the content or the body of the document. So I'm going to redefine respondent and principal. So therefore, John Henry Doe, hereinafter principal, all capital letters, request that, and actually, it's a different term. Remember up at the top, the definition was proper case, capital P, lowercase, rest of the word. In this case, I'm stating the name of the principal, hereinafter, principal, all caps. Those are really two different terms. Just like Brandon A. Adams, all caps, and Brandon A. Adams, upper and lowercase, are two different entities. These are two different words, two different definitions for each word. The principal at the top, which is upper and lowercase, includes a care of address during notary public. This one is just the name. Request that the balance of the account, which we have defined, be adjusted to $0 to reflect the ledgering of said tender.
Why did you capitalize 0?
Because you always capitalize numbers. Yeah, it's a proper name. You guys didn't know that? Yeah. Like if you were to write a longer number, like let's say I'm writing 700,336, it would be capital T in the 3, it would be hyphen 100, but the H would be lowercase. Or wait, what did I say? 3,000 or 3,000, right? So it would be 3, the capital T, HREE dash 1,000, lowercase 1,000, space 300 or 700, the capital S or capital T, whatever I'm using, hyphen 100, and then the word 36, where the T in 36 would be capitalized, hyphen SIX, and that would not be capitalized. You need to learn, I've learned all this through style. Look at English style manuals. Now, you don't have to learn it.
What's a style manual?
Style manual is how to interpret the language, how the customs of interpretation of the language.
Is there not a U.S. style manual and a Chicago style manual and all sorts of style manuals?
Hundreds of style manuals. There's legal style manuals for the interpretation of legal process. Okay? So, basically, whereas on such and such a date, tender for set-off for the account was presented for set-off to this party, whereas on this date, the tender is deemed accepted to set off the account pursuant to the evidence of the records enclosed. Therefore, principal requests that the balance of the account be adjusted to 0 to reflect the ledgering of the tender. Okay? Enclosed herewith is a request regarding a statement of account. Now, I've actually, in my process, I've removed this California Commercial Code because I don't depend on any code for anything. Mine is purely private contract. This particular process, they preferred to point to California Commercial Code. So I left it in there. Pursuant to California Commercial Code 9210. As a record, now literally I would just take out from this comma to that comma. So enclosed herewith is a request regarding a statement of account as a record authenticated by the debtor requesting that the recipient approve or correct the statement. So-and-so, this is CFO of the bank, hereinafter respondent, has 14 days. Notice how 14 and 14. Okay? Whenever you write a number in digits, make sure that that same number is written in letters and that the digits are in parentheses. Again, this is more style manual stuff. And actually, that should be capitalized.
I was going to ask you. Okay.
Has 14 days to comply with this request and provide an authenticated record. It's private contract, so I don't need that Section 9210 of the Commercial Code. I'm saying, here's a record authenticated by the debtor, and it's custom. This is, now, notice how I'm saying authenticated by the debtor, because who are the only parties who can authenticate the account and the amount owed on the account? The debtor and the creditor. Those are the only two parties that can authenticate a balance due on the account. So you have 14 days to comply with this request and provide an authenticated record. If the request regarding a statement of account is not corrected by the respondent within 14 days, looks like I got it right here.
Quick question, Brandon.
Yeah.
You said authenticated record. How would you know it's an authenticated record?
How would you know it's an authenticated record? What's that?
What are we looking for?
First-hand knowledge, but what would show, inform that it's authenticated? Signs it, right? Under penalty of perjury. I declare the following is true, correct, and complete to the best of my knowledge. That alone is that's a private authentication. You put penalty of perjury, that's a public authentication. I don't care what they do, private or public, authenticate it.
You consider a copy of that authenticated letter, or would you need a blue ink signature, in your opinion?
I would prefer a blue ink signature, but if they sent me a copy, I would consider it sufficient. If it had a signature where they declared that it was true, correct, and complete. Now, it's not a genuine record if they sent me a copy. What's that? What if they what?
What if they
That's not authenticated. And I don't recognize necessarily the elements of authentication that the public does. So the public may recognize that a typed signature, basically the name typed in, is a authentication. In my private contracts, that is not sufficient. Okay? Excuse me. So if the request regarding a statement of account is not corrected by the respondent within 14 days, then it shall be deemed accepted and or approved. Respondent's failure to respond within 14 days of the postmark of the presentment of this notice of tender for set-off shall cause the principal to have executed a certificate of non-response by the notary public listed below. Said certificate of non-response shall serve as evidence of the respondent's acceptance and or approval of this notice of tender for set-off and the enclosed request regarding a statement of account. Anybody ever received a notice from the IRS? Here's why you got this. Here's what you should do. You notice how they title their sections like that? That's what we're doing. We don't treat our party and contract as idiotic as the IRS likes to, but the IRS is just being real clear on the terms of the contract. Here's why you got it. Here's what you need to do. Here's what happens if you don't do it. They literally entitle their sections like that on the contract. They're making it real clear. We're making it real clear. We're getting their agreement, are we not? That the certificate that comes after this is going to be certifying their acceptance of the statement of account. And it's also going to be certifying the shall serve as evidence respondent's acceptance and or approval of the notice and the request regarding a statement of account.
Do you expect them to send you something back? Or?
No. And if they do, typically it's not going to be from the guy I addressed. And we will address that. We probably won't get to that today. Is it time for a break? And we probably won't get to that today, but tomorrow we'll show what happens when you're moving through your process and all of a sudden you get something from someone who's not part of the process, but may work at the bank. You know, you're corresponding with the CFO, but you get something from legal counsel or you get something from this guy over here. How do you handle that? You keep moving forward on your process, but you still have to address this guy over here. And actually, if you get something from someone else at that company, it is a blessing because now you're going to have two witnesses to your process and two people's agreement to your facts. It's funny. I've actually started to notice they're starting to, because people are becoming savvy to how to do this, they've actually stopped responding so much on your processes with the CFO because you're getting a double witness as soon as they start. Okay. Yeah, they didn't realize they were actually helping us. They're like, oh, sweet, we got a double witness. So now I got the CFO as a witness, I've got legal counsel as a witness, I've got a notary as a witness, and I got the post office as a witness. Who's got the solid process here? And I don't even have to get my hands on it. I don't have to testify to anything. I got 4 people. I got 4 parties to testify for me.
If you can hold it.
If I can hold it. With first-hand knowledge, indeed. Okay, upon the respondent's acceptance of the request regarding a statement of account, the respondent shall rescind any notice of default, notice of trustee's sale, and or trustee's deed upon sale. Notice how this is structured, so it's if you're in default, or they've issued a notice of trustee sale, or they already held a trustee sale. It doesn't matter where you're at in this in the process. This addresses all the points that could be possible. So, upon the respondent's and what symbolizes or certifies their acceptance? Their non-response. So, upon their acceptance, which was certified by their non-response, they're agreeing to rescind a notice of default, the notice of trustee sale, and or a trustee's deed upon sale by executing or causing to be executed a notice of rescission regarding the real property commonly known as 101 Main Street, Huntington Beach, California, County of Orange, assessor's parcel number, whatever, hereinafter, collateral, and file said notice of rescission in the office of the Orange County Recorder. Upon the respondent's acceptance of the request regarding a statement of account, the respondent shall also reconvey the collateral to the original trustor of the deed of trust recorded in the office of the Orange County Recorder on or about March 15, 2007 as instrument number blah, 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 by executing or causing to be executed a deed of full reconveyance and file said deed of full reconveyance in the office of the Orange County Recorder. What am I doing? I'm telling them to follow the public. Remember we said, before we started our procedure, we want to know what it looks like in the public, right? And so step one, right away, we're telling them what we want it to look like in the public. And we're getting their private agreement to have it look this way, right? But we're creditors, right? We're creditors. If they don't perform, what are we going to do?
We're going to do it for them.
We're going to do it for them. So, respondent's failure to execute or cause to be executed the notice of rescission and or deed of full reconveyance within 72 hours of the respondent's acceptance of the request regarding a statement of account shall constitute the granting and conveying of a specific power of attorney by the respondent to the principal for the principal to execute said instruments on behalf of the respondent. In addition, the respondent shall also grant and convey a specific power of attorney to the principal to execute a substitution of trustee and any and all instruments, communications, or correspondences the principal deems necessary for the perfection of the principal's paramount security interest in the collateral. Notice how I just put a catch-all in there? I'm like, you're granting me a specific power of attorney to do all this stuff and anything else I need to do. Right? Respondent shall give notice to the principal of the filing of the notice of rescission and or deed of full reconveyance by mailing certified copies of said instruments to the principal through the notary public listed below. Respondent's failure to give notice to the principal within 72 hours of the filing of said instruments shall be deemed a failure to perform and shall cause the principal to have executed a certificate of non-performance by the notary public listed below. Said certificate of non-performance shall serve as evidence of the respondent's acceptance and or approval of the granting and conveying of the specific power of attorney mentioned above. So what certifies the specific power of attorney? The notary's certification of their non-performance and non-response. That is my specific power of attorney. Any and all responses or notices regarding this notice of tender for set-off and or the enclosed request regarding a statement of account shall be directed to the principal by USPS certified or registered mail at the following address. Service in any other manner will be deemed defective on its face. Executed in Orange County, California Republic, the 6th day of the 4th month in the year of our Lord, 2010. Witness, my hand and seal. Why did I put executed in Orange County, California Republic? This is a private contract executed in the Republic. There are no public protections of limited liability here, my friend. Then it has the name of the principal, secured party creditor, executive trustee for the trust. All capital name letter, all capital name. Enclosures. Always, whenever you have something being carried in under a document like this, always mention or list everything that goes with it. Otherwise, everything after this document isn't there.
Our grammarian suggested that when you have enclosures, you take and make it enclosures as opposed to enclosure and or enclosures.
What?
You got the S on enclosures in parenthesis?
Uh-huh.
He suggested that you make it enclosures as opposed to that way.
Well, in style, if I do not cross out this S, it can be seen as either one, or it can be seen as the plural. You'll notice in notary form, they have in parentheses his, her, them. They'll have in parentheses his, her. It is actually the notary's duty to go through and cross out what is not pertinent. So if I'm dealing with a woman before me, then I'm crossing out him and them. Or I'm crossing out his and their and leaving her in there. Okay?
Anything in parentheses or boxes isn't there anyway.
Again, go to style. Okay? Look to style for this. This is English style. Now, in my enclosures, I have a request regarding a statement of account, which is 1 page. I have a notice to set off accounts. Now, actually, I've changed the format of this to where I have 2, and then I have my cover page, which is evidence of tender for set off of accounts. Again, my process I'll show you tomorrow, which is for another account, but it's the same notice of tender for set off. It's structured slightly different here in the enclosures and in the certificate of service, where there's a title page, which is record of tender for set off. And then under the record of tender for set off, I have the notice to set off accounts, I have the mortgage statement, I have the 1040-V, I have the certificate of service for the first presentment, step 1, and then the certificate of non-response that goes to step 1. That's all the record of the tender for set off. And then I have the certificate of service for this process. Okay?
What is your normal time delay between your sending out to the IRS the 3 previous mentioned documents and then your notice of tender for set off to include the certificate of non-response?
I've done it as soon as 1 day after. Because I had one girl who she was on a really tight timeline to get her process in because they were looking to, it was actually an IRS process where the IRS was looking to lien and levy. But we wanted to send the tender over to stop 4440, but we wanted to make sure that the IRS office who sent her the notice of levy got notice that we had sent their payment to another office at the IRS. So I sent it literally, actually I think I might have even done it, no, I did it 1 day apart. So the first day the notice, or the set off, the payment went in to Ogden, and then the very next day the notice of it went out to that other office saying, hey, you got your payment. It's over there in Ogden. Okay? This is a request regarding a statement of account. Again, you'll see one tomorrow that's part of another process where I've taken out any and all mentions to commercial code because you don't need it. Okay? So this is who it's to is the CFO of the bank. Who it's from is the executive trustee, okay, or secured party creditor, or whatever designation you give the private trust regarding, this is a request regarding a statement of account on behalf of the debtor and account number, whatever the bank account number is. Request regarding a statement of account pursuant to California Commercial Code. Now, on my new one, it just says, this is a record authenticated by the debtor requesting that the recipient approve or correct the statement indicating what the debtor believes to be the aggregate amount of unpaid obligations secured by collateral as of a specified date and reasonably identifying the transaction relationship that is the subject of the request. Recipient has 14 days to comply with this request and provide an authenticated record. Then you'll see a little title there, Statement of Account.
Brandon?
When I have certification of their acceptance and approval of this, remember you wanted your statement of account? Looky there, and it's got the balance you want on it, and you've got their agreement to it. So now you've got a record of what the statement of account is. We're the creditor. We're not waiting for them to do anything. And you've now got them to grant you a specific power of attorney to execute anything and everything that needs to be executed in their name. So you're not going to go do a reconveyance in your name, you're going to go do a reconveyance in the bank's name. Bank of America is reconveying this property by Brandon A. Adams as attorney in fact for Bank of America. You see? And trust me, documents get executed in the county records every day by attorneys in fact. Almost every document I've ever seen that's been recorded at the county for property is recorded by someone in the capacity as an attorney in fact.
Just like we had a guy in a criminal case. He put in, he was out after he got sentenced. He put in an appeal, his attorney did, and his attorney signed it for his behalf. And when he asked Jack and I, well, I never signed any appeal, because we told him he had to revoke it because he signed. He said, I never signed it. Did you have an attorney? He goes, yeah, your attorney signed it, so you signed it. He goes, oh, okay. So what Brandon's telling you is when you have an attorney, he's authorized to sign. What you've given yourself there, what they've given you through tacit acquiescence, is their approval for you to be the attorney in fact for this power of attorney. So when you execute it, they executed it, not you. They did. Somebody says, is that your signature? It's the bank's signature.
You see? And remember, you've got evidence of them granting it to you. Well, you will. Not yet. Okay, we're not there yet. We're going to take a break, and we'll show you what now gives you the power to execute all the things you need to execute, and then I'll even show you examples of what you're going to execute and file into the public record. And when you're all set, when this is all said and done, you've got a clear account. You've got all on the title side of the public records, it's all in perfect form. Nothing looks out of the ordinary. It all looks just like a regular payoff. And with this complete record, you can go in and do a quiet title if they still got a problem. They still want to push the issue. They still want to try to foreclose. Okay, well, let's go to court because I've got a complete record that you have no standing. I've got a complete record that I'm the only one with any standing in regards to this property. I don't need to argue the facts. The facts have all been witnessed by multiple parties. I don't have to assert anything. I've got 4 or 5 witnesses to the facts. Because after I've executed and recorded those county documents, I've now got the county as a witness. I've got the notary as a witness. I got the county as a witness. I got the post office as a witness. How many witnesses does that attorney have? None. He won't bring forward one. And when my evidence, my record by a third party is sitting in chambers in private commerce, and I will explain to you the significance of that. Because I had a judge actually come to one of my classes, and he explained the significance of the private side of the court, and it dawned on me why I had had success in the past. Because I had had a success in the past in court. I never showed up to court once. I never filed one thing into the public side of the case. They tried getting a default 6 times and were denied. And finally, the judge dismissed it. And I never showed up. And the judge explained to me why I had success. And I'll explain it to you. And why it's so important to really, more than anything, know how to keep this record. And work with a notary who's competent and keeps records. Because it's the notary's record that goes into the court, not yours. That's very significant. Okay? So, I think we've finished this process. We'll move on to step 3 after the break. Take a half-hour break. No, again, certificate of service is in here. And since we've already looked at one, they don't change much in form. Do you have a question? The non-essential.
If there's any non-essential items that have to be notarized, we've been using the notaries that actually work in the court administration. Court administration.
You mean like something like a jurat or an acknowledgement?
Correct. Any non-essential. These are all essentials, but any non-essential item that you want to have notarized that will never be questioned,
Yeah, that wouldn't hurt, because in that sense, now he's added another witness.
That's right. The court or the city administration notaries are always very helpful. They're never questioned. They never call the tab.
But you'll only get them to notarize acknowledgments and jurats. But you'll have that. As soon as we get into the next step, step 3, we start to move into jurats. Okay? So that's a very relevant point to be making, because now we can bring another witness in. Okay? Yeah, except when you get to the end. The car loan, rather than doing, and also actually that last step where we're talking about reconveyances of deed and things like that, we're not going to be talking about that stuff. We're going to be talking about releases of lien, right, to be filed with the DMV, right? Those are the things we're going to be mentioning in our notice of tender for set-off. And then when we get to the end, rather than executing a reconveyance or notice of rescission, we're going to walk into DMV, execute, release a lien on the vehicle for the bank. Yeah, I'm here for Bank of America to execute a release of lien. Who are you? I'm an attorney in fact for the Bank of America. Right? Yeah. And again, in the public, it's going to be perfect in form. It's going to be seamless. There's not going to be anything out of the ordinary in the public record. It's going to look just like any other payoff. Okay? So we'll take a quick half-hour break. Oh, one more?
Yeah, real quick. It seems like the notary plays a key role in all this. If you don't have a local...
That's an understatement.
Right. If you don't have a local notary, you could probably use somebody from out of state, but then that adds mailing time and so forth, so it'd probably be best to have somebody locally. If you don't have somebody locally, would you recommend that you find a friend who will become a notary, you become a notary, and then you notarize each other's work?
Absolutely.
Okay.
As long as there's not some kind of partnership between you where your friend would in some way benefit from the execution of your process, because that's a conflict of interest in the notaries. So just keep clean hands in your transactions.
As long as you're not doing any business together, but say you've been friends for 1 year or 10 years, it doesn't matter as long as you... Okay.
It doesn't matter. And you could be in business together. It just can't be that whatever they're notarizing, that they're going to benefit from.
They have to be an uninterested party. But all of you that don't have friends that are notaries, get them. Because when you need a notary to do your process, you're going to find a lot of regular public notaries, etc., are not going to do your mailings, or they're not going to cooperate with a protest or a non-response. So please, you all have friends, have them get some notaries. And we've got a lot of people that don't. So if you just live in the same area, you become a notary. It's not difficult. Matter of fact, I think felons can even become notaries.
No. Oh, yeah, they could.
Yes, they can.
They could.
Some of the states...
You got to be a felon who knows who you are.
Well, there's a couple, the Arizona says, have you been convicted of a felony that would preclude you from doing your job? Well, there's a different kind of a question. So check out your state rules, but get yourself some friends or associates, neighbors, somebody with a notary. Several of them, as a matter of fact, a couple of them. Even if you got to buy it for them, then they have it. Because when you need one, it's tough to get one.